In this day of stay at home and work from home, home has never meant more than it does today. Whether you're looking to buy, rent or build your new home, now is the time to get going. Gittins & Gittins real estate agents are here to take you to that place of your dreams. Let us take you home. We help you find that rental to rest along the way or journey with you to find your home destination. Investors and commercial enterprises too, call us and we'll walk the distance to place your business in just the right location. Owners, leave the headaches to us. We'll find your tenants or buyers while you stay at home. We'll even manage your property at your bidding. Anything real estate, come home to Gittins & Gittins Real Estate. Call us at 760-3280 or 747-1220 or visit us at 16 Fifth Street in Woodbrook.
Knowing how to tell authentic is as easy as 1, 2, 3. Find it, match it, search it. Step 1. Find the style number on the tag. Step 2. Match the style number inside the jersey with the number on the tag. Step 3. Search it. A quick Google search of the style number will verify the jersey is authentic when the search results match the jersey being searched. Don't be fooled by counterfeit jerseys. Before you buy, remember to find it, match it, search it.
Fan Zone, 2 locations nationwide. Center City Mall, Chaguanas and Movietown, Port of Spain. Nationwide delivery available.
Our award-winning show is back, and this season promises to be even more exciting than before. What's Up, Doc isn't just a title. It's a call to action for anyone who wants to improve their health and well-being. Join us on this thrilling ride towards better health on WESN Content Capital.
This is Face of Sports, WESN Content Capital. How you felt about the kiss on the lip?
That's the business. I'm nothing to do with that.
I find that was distasteful.
The national senior team, whether you like it or not, that is the model for all other teams to follow.
I'm assuming that the regional requirement may be a much stricter requirement.
This is not about Pro League and Super League. This is a league run by the Normalization Committee that I'm responsible for.
Nobody expected FIFA to fund this arrangement.
If we don't get a professional attitude towards this, we are doomed for failure.
You break the balance, trip the leg, control the body.
They ain't gonna stand put forever.
Why you want the Chiefs to lose so? Why you want the Chiefs to lose so?
They already have 2. Lamar don't
Why?
have.
You're jealous because you know the Chiefs getting closer to the Patriots. Let's go to the last part.
No,
of the
not no.
Let's go to the last part.
WESN.
This is 10 Questions. I'm Andy Johnson. Thanks for being with us. Say a good day on this day, this Friday. Let's tell you what's happening. It's been in the news. It's been the topic of national discussion for the past several weeks. It has to do with the police involvement in what happened to be the killing of Joshua Samaru, and then the shooting of Kaya Seeley, who were involved in that incident on January 26th. There's been a flood of discussion on the matter the last couple of weeks, an incident in front of the police headquarters. We're talking about it with attorney Farid Ali. He's taken some positions on it. He's sort of put together what are points for consideration. These are included. Joshua Samaru and Kaya Seeley were involved in a police chase on January 20th, 2026 that culminated with Joshua being shot 19 times and Kaya also being shot. What arose from those facts are Joshua's death and Kaya's paralysis as a result of the injuries sustained under police gunfire. The video footage that went viral itemized the closing moments of the police confrontation as opposed to a sequential moment-by-moment timeline of the events leading to the vehicle. Joshua and Kaya traveling in coming to a stop position at the corner of College Road and Bassey Street Extension, St. Augustine. Mainstream media and social media became flooded with public opinion that garnered sympathy for the civilians involved. After 4 months of police investigation, the Office of the Director of Public Prosecutions issued instructions for Kaya Seeley to be criminally charged with 3 counts of shooting with intent to cause serious bodily harm, as well as manslaughter relative to the death of Joshua Samaru. Public outrage has left most struggling with an understanding of how the facts and the law conspired to produce the outcome as we now know it to be. Mr. Ali is on the other end of the line. He's agreed to continue discussions with that because he's been expressing his public legal opinion on the matter over the last couple of days. We're happy that he's talking with us on the program here at 10 Questions. Farid, good to see you.
It's good to see you too. Thank you for having me.
All right. So let's get into it. As you say, you made a kind of case here to suggest that if these things, these observations that you make, if they are to hold, then the charges laid against Joshua and then lately Kaya, they are in order?
All right. Let's look at it from this point of view. Yeah. There's a certain amount of public mistrust for the process and the conclusion that born out of that process that charges ought to be referred against Kaya Seeley. In the court of public opinion, it's questionable. My position is this: if it is we are operating under the facts as brought into the public space by the police, then the charges that are deemed to be preferred against Kaya Seeley may very well be justified. I'm saying this: what the public is seeing is a 10-second video that reflects the culmination of a chase that began in Maloney and ended at the corner of College Road and Bassey Street Extension in St. Augustine. That is an 11-kilometer journey. That takes about, on average, 10 to 20 minutes, barring traffic considerations. Now, bear in mind, this is a high-speed chase, as we see. In movie language, if we put it that way.
Yeah.
When the police would have confronted the individuals, when the vehicle came to a stop at Bassey Street Extension and College Road in St. Augustine, the 3 police officers would have approached the vehicle. What the broadside of the vehicle that was exposed would have been the driver's side. So he would have basically fell into a ditch, or the vehicle came to a stop in a ditch against a galvanized fence. The police would have approached the vehicle, 1 from behind and 2 from the broadside. Their guns naturally being thrown or aimed at the driver. The reasoning particularly is that it seems from what is in the public space, there was a sting operation set up that Joshua Samaru was apparently communicating with someone who he wanted to transact guns and ammunition with, not knowing that individual was the police. And in the midst of the communication at Maloney, and upon his arrival there, he may have sensed, the way the narrative is being carried is, he may have sensed that, this is not who he was talking to on the phone, or it may not be the sort of transaction that he that in his mind's eye he was about to complete. In other words, he sensed something wrong, something went amiss. Realizing that perhaps it was police, he reversed and the chase began from Maloney that ended in Bassey Street. Now bear this in mind. Meaning a civilian. The civilians looking at things from the outside, looking in. They are only seeing what we saw, which is the 10-second video. They're not privy to all the information and the pre-story. They are just seeing the events as it unfolded in that 10-second video. When the DPP is looking at, and this is where the marriage of the facts and the law comes in, when the DPP is looking at this scenario, he's looking at it he's not looking at the video, you know. The DPP he would have had the benefit of reading statements taken from the police who would have been communicating with Joshua Samaru long before they all converged at Maloney on that morning of the 20th of January 2026. In other words, there would be pre-conversations that police would perhaps give a statement and say exactly what happened and what arrangement was made with Mr. Samaru for them to meet on the 20th of January 2026. And he would have indicated through his statements that he would have communicated with his seniors and a sting operation was put together where several other officers would meet and converge, and they would create a scenario in Maloney where when the transaction takes place, they would perhaps reveal themselves and place him under arrest. When he sped off, the plot changed, meaning the circumstances surrounding the events would have changed and they would have to give chase. It was not as simple as maybe they would have planned. Now understand this, that what the DPP is looking at is the statement given by that officer that he approached Samaru on the 20th of January, that he had a conversation with him, that Samaru was of the view that he was going to transact in the sale of a gun, and that the conversation with him, this is how the conversation went, and Samaru withdrew from the transaction at that moment and sped off in his vehicle. They would have, what is in the public space is that the cybercrime unit is in possession of the cellular phone used by the officer to communicate with Samaru on the morning. And I would imagine all his cellular data and messages, WhatsApp and telephone conversations would have been recorded or would be extracted from that phone. So at least what the DPP will be listening to is, and when I say listening by way of an exhibit, the data drawn from the cell phone would be reduced to a disk, and that disk would reflect the sound and the audio, and perhaps the video, if there's video, but sound and audio, reflecting the conversations had leading up to the 20th of January 2020. This is the kind of intuition that goes into making a decision as to whether there's criminal culpability involved. Now,
just before you go there, I wanted to see if we could make a distinction between the issue as it affected Joshua, then subsequently Kaya. In the beginning, it would seem that some people who thought they understood the facts were claiming that Joshua was attempting, or both of them in the vehicle, trying to get away from the police barrage, were attempting to surrender in a kind of way, but that the police refused to take that into account, and it ended up where the car ended up where it did, and other shots were fired.
Right. Now, if there was any attempt at surrender from from the narrative that came into the public space, that attempt at surrender took place at the corner of Bassey Street and College Road in St. Augustine. There was no attempt at surrender in Maloney. If there was an escape at Maloney, hence the police had to give chase. Now, let's take it to that point that you took me to, at the attempt at surrender. When Joshua realized that the vehicle that he ended up in a ditch and couldn't go anywhere, it was cornered at Bassey Street and College Road in St. Augustine. The police, one officer is standing behind the vehicle, two on the broadside. The one who was standing behind the vehicle, and I'm saying this purely on what is carried in the newspapers and the press. What is public information is that officer said he made observations that she had in her possession a gun, and the gun turned out to be a Glock, right? That is an automatic weapon. That in itself is a dangerous weapon. I mean, any gun would be, but an automatic weapon is something it's more dangerous. Now, when he noticed, that officer noticed from looking through the back glass that she had a gun in her possession, he said he noticed Joshua's left hand making its way towards the gun. Now, bearing in mind, we have two officers on the broadside who are not seeing what this officer behind the vehicle is seeing. So he is saying that at that point, when Joshua is reaching with his left hand, the officers on the broadside, they're only seeing Joshua's face, the glass was up. And then they only seeing Joshua's face. They're not seeing what's happening inside of the vehicle because of the tinting on the side glass. Now he is seeing because the back glass, the level of tint and the darkness on the back glass is not what the other officers are looking through when they're on the broadside. Now I say at some point in time, Joshua lowered the glass and stuck his two hands through the top of the lowered glass. In other words, the police officers are seeing two hands, which is an attempt at surrender. Now, what they're not seeing is that officer, those two officers on the broadside, not seeing that Kaya has a gun in her hand. And the officer behind, he is seeing that. Now, he said at that pinpoint in time, the officer who's standing to the back, that he hears glass crumbling. He hears a sound and glass crumbling. The sound he's insinuating is the sound of a shot being fired from that gun that is in Kaya's possession, and the glass crumbling is the glass crumbling as a result of the projectile being leaving her gun and hitting the glass in the direction of the police officers on the broadside. So in other words, she started pulling the trigger. She started firing first, and as a result of the gunfire that the officers on the broadside were subject to, they began to return fire. Now, Joshua's hand is in the air. What the public is saying is they're shooting into a vehicle where a man is trying to surrender. What they're not aware of, what the public is not aware of, is that what the police standing in behind the vehicle, the third officer, is seeing is that she's firing. She is shooting at two other officers. So that despite the fact that Joshua's hands are in the air, he may appear to be a non-shooter or innocent of trying to shoot at the police, but she certainly isn't. She is firing. Now, what are the officers supposed to do at that point in time? When you look at the angle that the officers are situated, and when you look at the video, you see that they are not seeing her, they're seeing him. And if they are not seeing her, they're not seeing what the third officer behind the vehicle is seeing. They are looking through tint and not seeing that she has a gun, but they begin to feel the effects of being under fire, meaning gunfire, when the glass crumbles and shots are ringing out from inside of the vehicle. What happens? They have to return fire. When they return fire, this is where the DPP would have chosen to prefer a charge of manslaughter against her. She, in firing at the officers, would have caused them to return fire. Joshua, being the recipient of 19 gunshot wounds, born out of the police returning fire, she is being held responsible for his death. Because but for her actions, the police would not have had reason to return fire and hence compromise Joshua's life. In other words, the police may have shot and killed Joshua, but they would not have had reason to shoot and cause his death but for her actions. In other words, the substantive cause of Joshua's death is the unlawful act of Kaya Sealy. And but for her actions, they would not have had to shoot at Joshua. So what the charge is that of manslaughter and the unlawful killing of Joshua Samaru by Kaya Sealy. What the public is not getting their minds around is the way the law works and the law as it relates to manslaughter. And what I could say is this: murder is the unlawful killing of a human being with the intention to kill, meaning that I point a gun at you and I pull the trigger. My intention is to kill you, and my actions of pulling the trigger and the bullet entering your body is the act that is responsible for your death. The intention when I pulled that trigger was to kill you. So hence murder, hence the charge of murder. But when the difference now is this: when the police officers shot Joshua, they did not intend to kill him. Their intention was to neutralize the force that was being projected in their direction. Now, the force that they're trying to neutralize may not have been coming from him, but it's coming from a secondary partner, so to speak. If I may use that word, secondary partner. Let me say it this way: it's coming from another person in the same vehicle. So Joshua and Kaya on a common enterprise to conduct a transaction with guns and involving guns and ammunition. It goes awry, and when confronted by police, Joshua is surrendering, but she's putting up a fight and shooting at them. So the officers return fire and he dies. So but for her unlawful actions in shooting at the police, they would not have had reason to return fire. So they're holding her responsible for his death. You cannot blame the police for Joshua's death when the police was simply doing what their use of force policy allows, which is when under threat to return fire and neutralize the threat that is being posed to them. Now, what persons may want to go and say at this stage is that it was too much force. It was 19 shots. But it was 3 officers, and they're using automatic weapons. They will continue to shoot as long as shots are ringing out against them. From what is being said, there were 3 shells found in the vehicle in addition to a Glock. So it means to say that by the time the exercise that was conducted by the police at the corner of Bassey Street and College Road in St. Augustine came to an end, when they opened the vehicle, not only did they found Joshua slouched over, they found a Glock by his feet, and they found 3 shell casings inside of the vehicle. Where did those shell casings come from? From the gun that was being fired.
So Ms. Seeley is saying that she, even at this point, that she's never handled a gun in her life. How can that be trashed as the details become, more advanced and that things become clearer? That you're feeling, given some of what you just said there, as laying out the situation as it was, which was not to the same extent available to people who might have been looking at the video, how the car ended up where it did. You think there are some missing facts that happened that have not been available for public view because of how the incident ended up?
If we are to believe the police version of the story, which is that they were shot at, then what Ms. Seeley is saying belongs to that higher order of truth that is fiction. In other words, Ms. Seeley is lying, if it is we believe the police version of the story. Now, the vehicle was taken to the St. Joseph police station where it would have been processed. And crime scene investigators would have treated it like any other crime scene when they would have examined, or any other exhibit, when they would have opened the doors and checked the vehicle. If it is Ms. Seeley did not fire that weapon, then why is there 3 shell casings inside of the vehicle on the ground? Why is there a Glock on the ground? If it is, she says she never handled a gun. So she never handled a gun. And Joshua's 2 hands are visibly outside of the vehicle. So who fired the weapon? A third person who disappeared? An angel, a ghost? The only person capable of firing that gun is Kaya Seeley. Now, I'm not taking her version of the facts for granted. I'm just saying that the evidence right now is heavily stacked against her. If it is we are to believe what is being said, after the vehicle was processed, a Glock was found in the vehicle and 3 shell casings. It means to say there is a gun in the vehicle. Was it a licensed firearm? What was the reason for that gun being in the vehicle? Why did the police give chase? Now, if it is we accept the police version that there's a Glock and 3 shell casings, there's another way to solve this problem, It's standard procedure when there is a gunplay and exchange between police and civilian that you would swab the hands and the clothing material of the suspects in question. So Kaya Seeley ought to have been swabbed for gunpowder residue. And that if their gunpowder residue was found on a person, she has a question to answer. You never handled a gun, you never fired at the police. So then why, after we do the forensic testing, we are getting gunpowder residue on your clothing and inside of the vehicle? Let me explain it this way.
Yeah.
When you have a Glock is a weapon that contains a slide and a butt. The slide is the horizontal part, and the butt is the vertical part that you hold on to. So she is holding. Any shooter has to hold the butt in order to grip the vehicle, and in order to grip the weapon. and your trigger finger goes in that intersection between the slide and the butt, where the horizontal meets the vertical. So your trigger finger goes there. Now, along the slide of the gun, the Glock, is a cartridge that contains shells, and inside of the shells are projectiles. When it is that fire, when you pull the trigger, the firing pin hits the cartridge that causes the shell to be released. When the shell that causes the shell to combust, when the shell combusts, the projectile in the shell is released. So Kaya would have been holding the gun. She would have pulled the trigger. The shell casing would have shattered, and the projectile would have been released. And three projectiles would have been released. The shells that each bullet would have been contained in contains gunpowder residue, and that when the trigger hits the shell, it caused the gunpowder residue to combust and the projectile to be released. So that gunpowder residue, there's a blowback effect when you start firing. 3 sets of gunpowder residue would have blown back into the vehicle against Kaya, and it would have settled inside of the vehicle. That's a lot of gunpowder residue.
Yeah.
It would have settled against her. She would have been breathing, so she would have inhaled some of that gunpowder residue, meaning it would have been caught in the hairs of her nostril. So it would be against her clothes, it would be against her trigger finger. It would be on the inner pores of the upholstery inside of the vehicle. It would be on the inside of the windscreen glass. It would be on the dashboard. And months after, it would be there. This is not mist. It is lead dust. Lead particles will be lodged in that vehicle as we speak. That Toyota Aqua 1703 that Joshua was conducting and she was in, if they were to examine that now, they ought to find gunpowder residue still if she was firing. So I don't think the DPP's office is an office of incompetence, and they understand expert evidence, and they understand the significance of proving that she shot and that she's responsible for shooting at the police.
All right. So what it is, the viewing public are not seeing that they should see, and understanding in the way in which the DPP has understood, and you elaborate on this legal term, but for, if something didn't happen, then other things would not have happened. And that's a major phrase in your language, but for.
That's legal language. But for her actions, nothing would have transpired in the way that it did. Had she stayed quiet, had she not fired at the police officers, they would not have to return fire, and Joshua would be alive today. Now, let me just bring some clarity to that, the charges.
Go ahead.
The charges that were laid were charges born out of what transpired, right? He died, Joshua is dead. It was determined that she was responsible for his death. She may not have shot Joshua, but she, in shooting at the police, caused the police to return fire, and Joshua died. So she's being held responsible for his death. It is what we call unlawful act manslaughter. Manslaughter takes 2 shapes and 2 forms. There are 2 categories of manslaughter, right? It's a common law charge. What we look at is this. You have voluntary manslaughter and you have involuntary manslaughter. Voluntary manslaughter involves somebody killing. They shot or they murdered or they killed or they chopped, caused somebody's death, intending to cause their death. But that act of killing was a provoked act, meaning that you caused me to bring harm to you, or you caused me to cause somebody else's death by the things you said. Let me bring that to you in a live way. If there's a domestic dispute and the wife says to the husband, but that boy is not your son, they get away, and in the argument, she reveals that the boy he was treating as his child for so many years is not his child. And he loses self-control in that moment and finding out, but wait, now you mean Jeffrey is not my child? All these years you make me feel that the boy is my boy, and now you're revealing so-and-so. And he reacts, having lost control in that pinpoint in time, and kills her. He may have had the intention to kill when he did, but because of her words and her provocation, he did that. In other words, it was triggered by provocative action by the woman, or provocative action by the things she said, and And therefore, he reacted like that. In other words, the law provides a partial defense to someone who was provoked into the activity. So he would not have killed her but for her provocative words. So that his intention to kill may have been there, but the charge of manslaughter is applied because it was inspired by things she did. It's a partial defense, a partial defense of provocation. Another one in terms of voluntary manslaughter is a person may have intended to kill, but the person is schizophrenic, the person have a mental illness. They don't have control over mind and matter. They may not understand the nature and the consequences of their actions. So a man may attack a woman and chop her up in the road. Or he may attack a child and stab the child to death and behead the child. But he believes in his mind that he's not killing a child. You know. His mind is so impaired and his reasoning is so affected and impacted that he believes he's chopping up a snake. In other words, his mental illness doesn't allow him to understand that what he's doing is taking the life of a human being. Right? That may apply in instances also. I mean, if I would just shift the example, in instances where a woman may have been subject to domestic abuse, beatings from a man over the course of 25 to 30 years, she has become so mentally impacted and impaired that she's operating in a realm where she has become clinically suffering from a clinical condition where she doesn't understand the nature and the consequences of her actions. So hence what we call diminished responsibility. She doesn't have the capacity to understand her actions, having been subjected to abuse over a protracted and prolonged period of time. Now that's the voluntary aspect. This is where we are with TSCD now, the involuntary.
Yeah.
Involuntary has to do with two categories, either gross negligence manslaughter or unlawful act manslaughter. Gross negligence manslaughter has to do with a professional having a duty of care towards an individual. He did not execute his duty of care in a manner that is consistent with what his responsibilities are, and the person dies. And a common example I like to use is that of, let us say, a doctor performing a surgery.
Right.
When the doctor is hired to perform an open heart bypass surgery on an individual, if he turns up there drunk and disorderly, and he cannot fulfill his function in a way that is consistent with the international best practices of a surgeon, and he performs a botched operation and the individual dies, that duty of care that he owed his patient to perform a responsibility in a manner that is consistent with that of which his profession requires, and the individual suffers loss and he dies, then his gross negligence caused the death of the individual. He may not have intended to kill the person, but he fulfilled his function in a way that is not consistent with what professionals do. So hence gross negligence. He could be charged for manslaughter, but the manslaughter charge would be laid purely on the basis of he was negligent in how he did what he did. He didn't intend to kill, but he didn't. But what caused the charge to be laid is that he performed his task in an irresponsible manner, inconsistent with the standards expected of somebody in his fulfilling the function he is fulfilling. Now, this is where we are with Kaya. Her unlawful act manslaughter is when somebody commits an act or executes a function that is unlawful. So when she shot at the police, her unlawful actions of shooting at the police caused someone to die. And she may not have intended to cause the particular person to die, which is Joshua Samaru, but her unlawful actions caused law enforcement to shoot in her direction, and he died as a result. So, but for her unlawful actions, he would not have suffered in the manner that he suffered, which is to be the recipient of 19 gunshot wounds, or the recipient of 19 shots from the police, which compromised his life. So, unlawful act manslaughter hinges on an individual committing an unlawful act that created the circumstances where someone suffered loss of life. She by her actions created circumstances where she created an endangerment to him that compromised his life, and hence unlawful act manslaughter. She would, when she goes before the court, be entitled to bail, it is not a murder charge, and even murder charges in this current dispensation is a charge that it's bailable now.
So what do you think is missing? The people who staged that sort of protest in front of was it police headquarters, and some people got arrested. How critical, is it that they are not reading? They're not able to read the development of these occurrences to have given them an understanding of when the DPP is advising to lay the charge of manslaughter on the lady?
In my view, there are certain key elements in the society, institutions that ought to create public education programs in instances, particularly when something like this transpired, in order to get the population on board with what is taking place. Let me say it in another way. There's the Law Association, there are the Eastern Lawyers Association, the Southern Lawyers Association, there's the Central Lawyers Association. These associations have a responsibility to put into the public space the sort of dialogue that you and I just carried, where they explain what murder is, what manslaughter is, and without particularizing the synopsis in the context of Kaya and Joshua, at least take the population to a point where they understand the rudiments and the building blocks of a murder charge and the building blocks of a manslaughter charge. So it will take the alarm out of the population, and it will bring understanding and clarity to the population in such a way that they will understand it's feasible that a charge of this nature could be laid. It's the lack of education that is causing those protesters to perish right now. They don't understand what you and I understand, and some of them are incapable of understanding that. In other words, they've already tried this matter, and they've concluded, and wrongfully so, if it is we are to believe the police version. Now remember, I'm housing my argument along my explanation on the basis of the DPP doing the correct thing in laying the charge, because we don't have the information that the DPP has, but we have the trust and confidence that the institution knows what it's executing on a day-to-day basis. They are trained legal minds, highly trained legal minds that sit and make decisions on a day-to-day basis. Yeah. The public and those people protesting don't know what the DPP knows. They don't have the statements, the exhibits. They don't have access to the crime scene investigators report. They don't have access to the photographic supplements from the crime scene that would have informed the DPP in making a decision. They simply don't have the pathologist report that reflects what were the causes of the death of Joshua Samru. The post-mortem report and the death certificate is reflective of what would have compromised his life. Now, yes, it's gunfire, but the marriage of the statements from the police, the formal witnesses, the civilian witnesses, the CCTV footage, all of that is what the DPP had the benefit of. Yeah. Those protesters on the street have nothing. Right. All they have is public opinion.
And that is driving what you describe as a certain measure of sympathy. They weren't able to see the way in which, and I wanted to divide that question in two, is that it appears that what was happening in the vehicle, at least the portion of the tape that was shown, was not sort of visible to people on the outside. And some of what transpired then, people aren't accepting it because they weren't able to see it from the side of the vehicle that it was happening, correct?
Exactly, and I think that we have to knock the police for this on some level too. There's a police communications unit that is responsible for giving releases on a day-to-day basis or as often as they choose to. If they recognize that people are drawing conclusions and wrongfully drawing conclusions and casting aspersions on the activities that took place on the 20th of January 2026, then they can simply reveal, listen, we are not in a position to tell you what we know, but there was a sting operation. They could give you the basic story that there was a sting operation being conducted. Those people that we gave chase to in the vehicle, who you would perceive to be two simple individuals, we have reason to believe that they were about criminal activity, and that when the vehicle came to a stop, they fired at the police officers, and the police officers returned fire. When we opened the vehicle at the St. Joseph police station and crime scene investigators processed the vehicle, they found a gun inside with 3 spent shells. So therefore, there is enough information that put into the public space that the individual shot at the police before the police shot at them. The police embarked on an exercise neutralizing a threat close to their person when they shot into the vehicle on the day in question. If that basic information is put there, that cannot compromise the police investigation in any way. If it's anything, the basic story cannot change. It took 4 months for the police to reveal to the public that a Glock was found in the vehicle, that 3 spent shells were in the vehicle, and that she was firing at them. So the police courted this problem and fueled the fury that we are seeing in the public space right now by being quiet about it. And this is a fault of the police in that sense. There is nothing wrong with providing information in the public space. It doesn't compromise your investigation. If it's anything, it eases the conscience of the people, and it brings a certain amount of calm within the community, and it prevents public uproar when it is you provide the basic information that the public could digest. You allow the public to spend 4 months.
Was too long? You think that's the point you're making? It took too much of a long time to get from there to here?
It was a ridiculously long period of time, but it's what happens in Trinidad. We perhaps at this stage need to revisit how, and when I say we, I mean our criminal justice system and the way we provide information to the public needs to be addressed in some way, and criminal justice system is particularized in this instance at the police. If it is they were to reveal to the public the circumstances, a basic outline of what inspired the police chase and the way things culminated, at least it would take the fear and the unease out of the public mind. You allow the public to munch on and to digest these facts with limited information for 4 months. They created the speculation that we are experiencing right now. They created the public alarm by their actions. They caused the public to digest, process, and internalize things from the perspective of what the video is revealing, and not from the perspective of the pre-story and the perspective of what transpired in the vehicle and what the science revealed at the very end. Imagine the public looking at a 10-second video with no information. All you can repeat in your mind's eye, and all the public is reliving on a day-to-day basis, is police shooting into a vehicle. They have no information that the young lady had a gun in the vehicle, that she shot at the police. They had no information as to what the officer standing in the back of the vehicle saw. And they're simply, meaning the public is simply continuously living in the horror of watching 3 police officers shooting at unarmed persons in a vehicle. Had they been aware, had the public been made aware that those unarmed persons, those Joshua's hands were out, the woman was shooting at the police, then they may very well accept that there was something criminal taking place. Now, again, I say, I'm not judging this, I'm taking the side of the police in this matter. I'm saying that if it is what is being placed in the public's eye now, within public view, is that she was shooting at the police, why wait 4 months to reveal that? Because if it was potentially capable of compromising the investigation in January, is it not compromising the investigation now in May? Because she has not been charged, there's a warrant out for arrest and a charge is to be laid. We are perfectly capable of discussing this matter because it has not reached the court and charges have not been laid. Our discussion very well may be deemed or may be seen in the police eyes as, somewhat compromising their investigation, because the investigation remains open. They could add things, fresh evidence could present itself, the charge has not been laid. Even when the sufficiency hearing starts in whatever time after the charge is laid, the next step is the sufficiency hearing before a master of the court to determine whether there is enough evidence for a judge to try this matter on. Even at the sufficiency level, more statements could be added. Even when the matter goes before a judge in a year and a half time from now, fresh evidence applications could be made for further statements to be added to the bundle. So the investigation, the fear that the investigation will be compromised by putting things in the public space, is hypocrisy on the part of the police to say that that fear existed and subsisted in January, but it doesn't subsist and exist in May. The same time, they took 4 months to reveal certain things. They could have revealed this as early as January 20th.
So you think they took too long to get to this point?
Too long to provide information that you provided anyhow. You withheld information between January and May, right? And released the information at the end of May, 4 months after, and on the basis of there's an investigation, we have to respect the investigation, and there are certain things that we cannot see while this investigation is going on. But you did the same, you did it anyway. So what is different between January and May? You took 4 months. It makes it look as if there was some reason to cover up or to cover things up in some way. That it invites the public to speculate that the police was involved in a major cover-up over the past 4 months. And this theorizing that there was a cover-up could have been taken out of the public's mind by revealing the information as early as the 20th of January or within close proximity to the 20th of January. So when we read that, this is a big cover-up, they have brought the police, by taking so long, 4 months, to put this in the public space, have invited this sort of analysis, that there is a cover-up and that there's something to hide, and invites the public now to speculate as to whether this is a carefully orchestrated exercise by the police over the past 4 months to come up with a defense for the actions on the day in question. All of this could have been avoided.
Yeah, and then what comes across, it is as though there were things happening in the vehicle that would not for the public viewing, so people didn't see some of what was happening, and police were responding to that, because one of the parts of the proposition is that police were shooting while, whether it is Joshua or Kaya, was seeking to surrender in a kind of way, or to say, well, this is peace going on.
Right, and the police version is they weren't trying to surrender, they were shooting. Now, the flip side of it is, in these modern vehicles now, one has asked the question whether there's three-way cameras. Those cameras that there's a dash cam that records everything that's happening in front of the vehicles while you're driving, and there's a reverse camera, so when you're reversing, you'll see the behind the vehicle when you're reversing. There's also a third camera, that third camera captures everything inside of the vehicle. If there's any sort of any camera work that vehicle contains, meaning that an accessory that is added to the vehicle involving dash cam, reverse cam, and camera footage of what is in the vehicle, there very well may be camera footage that when the CSI examined the vehicle on the 20th of January, they may have seized that actually captures in real time she holding the gun and firing. What if it is that happens? What if it is because in my vehicle I have such a camera in case something happens? That's an accessory that I added. Most people tend to do it now. Everybody has these three-way camera systems. It very well may be one of those. What if it is that presents itself? That may very well bring to closure the speculation that she's innocent. And if it is that camera does exist and footage from it is revealed, it may bring to closure the speculation and reveal that she never had a gun, no gun was fired. It will capture the imagery inside of the vehicle in the way that she claims it ought to reflect, which is she never handled a gun and she never fired at the police.
Okay, make the point you're making before I ask the question.
Right. So I'm saying that she very well may be someone who never handled a gun and never shot at the police. If it is the crime scene investigative report is complete and presented. But something, we have to pick sense out of nonsense. If that was so, and she did not fire, then why did the DPP give instructions to prefer a charge? What was the basis for that decision made by the Director of Public Prosecution's Office? The DPP, if they had seen the video footage that captured what happened inside of the vehicle, would be able to say, well, the young lady never fired, she never shot at. So therefore, your police version that she shot at them and they returned fire is not true. And then the charge of unlawful act manslaughter may not have been preferred, or may not have been couched to be preferred. I am of the belief that the DPP is a very knowledgeable individual, and his office is not going to make foolish decisions. There has to be sufficient evidence that triggers the need to lay a charge on her. And the science may very well prove her wrong.
Yeah, I mean, the issue is that for a lot of people, it's kind of surprising that the DPP will advise in the way that he has. But that is unique, isn't it? He would have looked at all the evidence that was available to be looked at. And people who just couldn't believe it were the people who were on the streets.
Well, the persons who believe that, who cannot believe the DPP will do such a thing and instruct a charger, are the persons who don't understand the dynamics and the rudiments and the science of how the law is applied in relation to facts. They don't understand that you could be held responsible for the death of someone by your actions. They don't understand that by she shooting at the police and causing the police to lawfully respond. When the police shot at Joshua, they were lawfully responding to neutralize a threat placed to their person. But for her actions, they would not have had to respond with deadly force. So the persons who are complaining that why is the DPP causing this young lady to be charged for manslaughter and the unlawful killing of him, when clearly the aggressors were the police. But they don't understand that the DPP would have given that instructions because the DPP is sufficiently satisfied that but for Kaya Citi's actions, the police would not have had to respond with deadly force. So the public doesn't understand the law and the application of the law in the way that lawyers do, and in this case, in the way that the DPP, as senior counsel, does.
All right. So, what do you think, as it goes along, people will get a better insight into more of the action that took place that has been available to this point, and the sense of outrage that you saw on the streets with the demonstration, some of that will be put into a better context?
All right. That outrage that took place there and that protesting is not going to impact on what happens in the courtroom. That is what you call pre-trial publicity, right? The reason why it is the police and the arms of the state are reacting in the way that they are about the protest is that the protest is unnecessary. The protest is preempting the trial process. In the trial, the truth will come out. The truth as to whether she was the aggressor and she caused by her actions the police to fire and therefore caused Joshua to lose his life, or it will prove that she was correct, that she did not fire and that the police used force, and they use force beyond that which was necessary to neutralize the threat. I am of the view that we should be patient with the process. We have no choice. I have seen this play into the public's face for many, many years, and I've seen the public reaction for many, many years. This is not the first instance. I remember in 2020, there were 3 individuals that lost their lives: a 17-year-old Fabian Richards, a 22-year-old Fabian Richards, a 17-year-old Leonardo Williams, and a 17-year-old Isaiah Roberts. 3 individuals who were in a vehicle, and police engaged with the vehicle and said a Glock was pulled on them, 5 shots were fired at them, and the police returned fire. When the pathologist report came through, it reflected that all 3 individuals died from gunshot wounds, where bullet entry wounds were to the back of their person. So the science disproved the police version of the facts, meaning that the police shot them from behind and killed them, whereas the police is saying the reverse of, that they were engaged with them and shot at. I'm using that analogy to say public opinion does not matter. In that instance, I just gave you the parents and the family and the community for these 3 young men came out and there were candlelight vigils. And the science doesn't lie. You can say what you want. At the end of the day, the science will disprove or prove. And if the science proves that these individuals, Kia Sili and Joshua Samaru, confronted the police in such a way that they brought upon themselves what transpired, meaning that the police had to shoot at them, then we may very well see the court determining this matter in favor of the police. I'm not saying the police are saints. I gave you an example using those 3 individuals where the police have used excessive force and they've offered a version of the facts that turned out to be untrue. That matter involving the 3 young men, the police gave a version that the science disproved. The pathologist report showed bullet entry wounds to the back of the person. If I use another quick example, in that matter involving PC Gilks, I believe that was 2022. PC Gilks was an officer who in Rich Plain, in Diego Martin, was part of an exercise where they were shooting at individuals who were shooting at the police. When Gilks died, McDonald Jacob said that he died under gunfire from the person shooting at the police. It turned out that contrary to that he died from gunfire where the police shot Gilks in the back of his head, meaning that they shot and they compromised the integrity of a person that is a police officer in their company. Sometimes the police get it wrong. Sometimes the police get it right. I'm not saying that the police are correct without hearing what the evidence is revealing in this Joshua Samaru and Kaya Seeley matter. I'm saying that we are going to get the truth through the processes of the court over the next few months. And we have to trust the science and the process. The protesting on the street is creating an environment that is unwholesome and unhealthy, and it doesn't add value to what is the process ahead. If it's anything, this sort of pre-trial publicity, meaning generating and public sympathy by protesting on the street and putting one side of the story out in the public space, it is going to color people's opinion generally. If this thing goes to a jury trial, where are we going to get 9 persons who are going to give our opinion that is unfiltered, meaning that they're capable of divorcing their minds from what is in the public space? In other words, you walk into that courtroom carrying a mindset that these people are innocent, that they were taken advantage of by the police. It makes it difficult for a fair hearing or for persons to deliberate, meaning a jury to deliberate, without having a preconceived notion of things. Luckily, we live in an age where there are what we call judge-alone trials. There's no jury involved. So if it's a juryless trial, then the judge will be able to apply his or her knowledge and being able to divorce his or herself from what the sensationalism we're seeing on the street encapsulates and creates.
All right, we're flat out of time. We have to leave it there, my friend. Thank you very much, Farid Ali.
I'm grateful for the opportunity. I hope what I've said has been helpful to you and the listening public.
All right, thank you very much.
Enjoy the rest of it.
You too. We'll see what happens as we go along. This has been 10 Questions. I'm Andy Johnson. Thanks for watching. We'll see you next time.
WESN